Case number 114890, Pamela Heimerman et al. v. Zachary Rose et al.
May it please the court. Scott Mann on behalf of the appellant, Pamela Heimerman. May I proceed?
You may.
This court, Your Honor, stems from the settlement of a wrongful death action arising from a motor vehicle accident. My client, Pam Heimerman, is the surviving spouse of the deceased, Dan Heimerman. The wrongful death case was alleged against another driver, and two actions were actually filed. One by the son, who was a resident of Florida, in Kansas federal court. A second action was filed by my client, Pam Heimerman, the surviving spouse, in state court, Allen County. Over the objection of Lucas Heimerman, Pam Heimerman intervened in the federal court action. Both actions were pending. After discovery and mediation, the wrongful death case was settled. An apportionment hearing was held in federal court to determine an apportionment between the heirs of the settlement, of the net settlement. The issue of the workers' compensation lien was reserved pursuant to the statute that is being interpreted on appeal, 44504B. Pamela Heimerman filed a motion in the state court action, which had not been dismissed and was pending, asking the court to apportion the workers' compensation lien. The state court dismissed that motion and the action based on the intervener's motion to dismiss. An appeal ensued to the Kansas Court of Appeals, and the dismissal was affirmed, and now Pamela Heimerman has requested review of the statute and the particular lien statute with the Supreme Court. This appeal involves the interpretation of 44504 and specifically the amendment that took place in 1993. The statute, the first part of the statute has been unchanged, and I'll just read it. In the event of a recovery from such other person by injured worker or by judgment, settlement, or otherwise, the employer shall be subrogated to the extent of the compensation and medical aid provided by the employer to the date of such recovery, and shall have a lien, therefore, against the entire amount of such recovery. That part of the statute is unchanged. What is changed in 1993 is the legislature added this, excluding any recovery or portion thereof determined by a court to be loss of consortium and loss of services to the spouse. The idea behind this statute, the intent of the legislature, is to avoid a duplicative recovery. Let's apply it to the case we're here about today. Pam Heimerman's husband of 25 years was killed in an unfortunate automobile accident. Her net recovery due to limited insurance for the other driver was approximately $248,000. The settlement was actually more than that, but there were two heirs. And as this court likely knows, there's a provision of the wrongful death statute that allows the heirs to go to court and determine who gets what. That actually occurred in federal court. There was actually a state court action pending and a federal court action pending. The parties elected to go to federal court. The federal court, Judge Murguia, heard evidence about the two heirs and their relationship with Dan Heimerman. There was an adult son who is not Pam Heimerman's natural son, but is Dan Heimerman's natural son. And then there is Pam Heimerman, who is the wife of 25 years. The federal court first, under the particular statute, determined what the expenses were, what the attorney fees were, and then apportioned 90 10 between the two heirs, 90% to the spouse, 10% to the natural son.
And that apportionment was done pursuant to the wrongful death statute?
It was.
Was there anything preventing your client from litigating the issue of how to apportion the types of damages she was recovering at that point?
There was not. That issue was.
So why didn't that
Well,
happen?
that issue was not before the federal court at that time.
Well,
it
it wasn't
essence,
placed before the federal court at that time. I just asked whether there was anything preventing her from placing it before the court, and I thought your answer was no, there was nothing preventing it.
correct.
So it was a choice.
Well, I think that's a bit unfair to my client. And what I mean by that, let me explain, is when other issues were brought up at that apportionment hearing, the federal court said the only issue before me today is a motion to apportion and a determination of attorney fees. So that was determined on that date by the federal court. A journal entry was then drafted by the parties reserving the workers' compensation issue to be raised at a later date if it could not be resolved. I would specifically read from the journal entry, because I participated in the drafting of it, that basically indicated that it's paragraph 24 of the federal court journal entry, that my client would satisfy.
It doesn't express a reservation, it just says she'll satisfy.
Pursuant to. We would satisfy
What
all
part
valid.
what part of the statute is in question here?
I think the part that's in question is my client's request to have a court determine what portion of her settlement is loss of consortium and loss of services.
Well, I understand there's procedural questions here. Which court will actually make the determination of the type of damages your client suffered?
Right.
But no one's refuting that the statute says there is subrogation. You agree that the insurance company's entitled to subrogation under that first part that you read, do you not?
We agree that the statute provides the workers' compensation carrier, Republic, a valid lien against a recovery.
So the answer is yes.
Yes.
And your
Excluding.
opposing counsel doesn't refute or try to interpret the statute to deny that loss of consortium or spousal services is exempted. There's no challenge to the interpretation of that part of the statute, is there?
Correct.
So all we're talking about is the type of damages encompassed within the $248,000.
Correct.
So I don't understand when you say this is an issue of statutory interpretation. It sounds to me like we got a factual question.
Well, I guess I would say this. The Court of Appeals, well, I should start with the District Court. The District Court and the Court of Appeals read into the statute that the only court that could make that determination is the court that approved the settlement. We point out.
Your position is you ought to be able to pick the court.
Not even
gets
that.
to do that.
Not even that. If you look at
Nothing
this.
prevented you
Yes.
from taking this issue to the federal court. You made a conscious decision that you wanted some other court to do this apportionment. And that's why it didn't come up in the federal court, and that's why you wrote the settlement agreement the way it was, because you were intending to head to state court.
Correct.
So the issue is, do you get to pick the court that makes that determination?
As long as I pick a court that has jurisdiction, correct.
Yeah.
Well,
So
can I just interject, and then I'll. The procedural facts of this case are important. In that we made a choice not to bring it up in front of the federal court, but to reserve it, take it up in a pending action, the same wrongful death pending action in a state court. The state court, in my opinion, erred in saying this has already been determined by the federal court. It had not been determined by the federal court. It had never been raised by the federal court. But the district court then dismissed my request to have the loss of consortium, my day in court, the loss of consortium, the loss of services addressed.
Counsel, what was the precise error that you allege the district court made? Because I just heard you say what appeared to me to be two different things, that they made an error, kind of a factual error, that this had already been determined. But earlier you said the district court interpreted the statute in such a way that it didn't believe it had jurisdiction. Those are
Correct.
two different kinds of errors.
Thank you for allowing me to clarify. I think the district court erred in stating that that this had been raised by the federal court and determined by the federal court. And so it.
An error
I
of
think
fact.
earlier you were talking about the Court of Appeals error. There are two different types of error, it sounded like to me. You said the district court erred, if I may. I thought what you said was that the Court of Appeals erred by saying that the court that approved the settlement must be the court that does this apportionment.
That's correct.
Whereas the district court, differentiating, erred by saying it had already been determined by the federal court.
Correct. And
So
that
those
it-
are the two errors you're alleging.
Correct.
Okay, thanks.
And what I'm asking for, just so that I can be specific, is I'm asking that the case be remanded to allow the district court to hear evidence on this issue and make a determination as to whether any of the monies recovered in the wrongful death case constitute damages for loss of consortium and loss of services, which will then determine the amount of the lien. Old Republic has a valid lien. They paid work comp benefits. But the lien does not attach to any portion of the wrongful death settlement that is determined to be loss of consortium and loss of services as determined by a court. My point here today, despite all the convoluted procedural stuff that went on in this case, is no court has ever been presented that evidence and made that determination. It's never been brought before any court. And specifically, when we were in front of the federal court approving the settlement, all we were asking the federal court to do was apportion between the heirs. Because not until my client found out how much money she was going to receive out of the settlement would she know whether she was going to be required to address a workers' compensation claim.
So
One last
what gives the district court jurisdiction over the federal settlement proceeds in order to do what you want it to do?
44504B.
Well, is it really jurisdiction over the settlement proceeds, or is it jurisdiction over the scope of the lien?
I think that's an important point. All we're trying to determine at this stage in the litigation is not whether the lien is valid, but whether the lien attaches
Scope,
to the
the
settlement
scope of the
proceeds.
lien.
So we're merely trying to determine a Kansas workers' compensation lien under 44504. And the statute is very specific. It says a court. It doesn't say the court. It doesn't say the settlement court like the hospital lien statute. It says a court. And under these facts, clearly, this issue was never brought up and decided by the federal court. At one point in the Court of Appeals decision, it says Pam Hammerman's trying to relitigate the workers' compensation lien. That's just an untrue statement. We never litigated the workers' compensation statute. We specifically reserved it. In fact, the federal court, after the district court dismissed and said, look, this really should have been taken up with the federal court, which I disagreed with, but that's what the district court said. We then asked the federal court to reopen the case and address the workers' compensation lien. And the federal court, and this is in the journal entry, states this.
And that federal journal entry is in our record.
It is.
I
we
understand,
made
I
it-
understand it's there, but I'm kind of puzzled as to how we consider it when it wasn't considered by the district court below. You understand? I mean,
It was.
technically it was not before the state district court ever, was it? Because it happened. It was a post.
There are two orders, just so that we're clear here.
I know
there
that.
was the journal entry for the settlement,
I
and
know
then there
that.
was this
I'm
subsequent.
talking about the later one on the motion to reopen the federal case. So it's just a weird procedure for us to consider a document from a federal court that was not entered until an order from a federal court that was not entered until after the state court proceedings were completed.
Yeah.
When it's the state court proceedings that we're reviewing.
I don't know that I have the answer for you on that.
Okay.
Other than,
I know it's in
other
there,
than,
and both of you talk about it, so
Yeah.
maybe it's in there by some sort of agreement, but that's not typical for us, you understand?
Other than going back to what the justice said, this is an issue of the interpretation of a Kansas statute regarding a Kansas workers' compensation lien.
But it's under the
struggling
workers,
with that.
but it's under the wrongful death statutory provisions, correct?
It's not. It's
You
under the
think it's
Kansas
separate?
Workers' Compensation
You
Act.
think it's separate, so that, is that the basis in which you divorce your argument from the one action rule of wrongful death? Or do we have to consider the one action rule of wrongful death in looking at this statutory interpretation?
Well, I don't think you have to look at the one action, because I think liens can always be taken up after the resolution of the claim, either by the court that resolved the claim, or if it hasn't been brought up by the court that's resolved the claim, by any court of equity.
And your authority for that is just general
The
equity
statute.
or
The
the
statute
statute?
says a court, determination by a court. In this, if you
So
look
you
at the,
see that as a totally separate action, or?
I see that if it's not been determined by a prior court, then I think it can be brought up at a late, and it's been reserved, which in this case it was. It was specifically reserved and not addressed by the federal court. I think it then can be brought up in a separate action. And I realize this causes you some procedural problems, but the district court said, I can't address this. This was addressed by the federal court.
What does
Right.
the district court have to do? Let's just
Okay.
assume the district court's doing what you want it to do. What does it have to do in order to make those decisions? Does it have to hear evidence about your client's various damages, the wrongful death damages, and then make a decision how much of the pot goes to one place or the other?
The purpose of the statute is to avoid a duplicative recovery. We obviously know when we make a claim like this, it's for past medical, for past wage loss, in this case wrongful death, future wage loss, loss of consortium, loss of services. Those were all itemized in a pretrial order. Judge Kreitz actually conducted an evidentiary hearing. He first said, look, I'm going to take up the motion to dismiss and motion to stay. He heard argument on that. He said, now I'm going to hear evidentiary testimony on Pam Heimerman's claim for loss of consortium and loss of services. We had an economic report addressing loss of services. We introduced that. Pam Heimerman testified about her 25-year marriage and the loss of her husband 2 weeks before their 25th anniversary. Based on that evidence, he then can determine whether the $250,000 or $248,000 that she recovered is duplicative of the $300,000 of workers' compensation benefits she's receiving weekly, which replaces this gentleman's loss of income. We also had a loss of income report that we introduced showing that the loss of income was over $2 million as a result of this accident. So our argument was this was not a duplicative recovery, and that's the intent of the statute. You should apportion, based on the evidence we've presented, the $248,000 to loss of services and to loss of consortium. My time is up. Thank you.
Could I have a question?
Certainly.
I understood you to say that this determination is under the workers' comp as to how much of the damages were loss of consortium. But if this had not been, if he hadn't been in the scope of employment and we just were dealing with the tortfeasor, Ms. Heimerman would have been asking for those type of damages. They would have been separately out, they would have been pled, you would have had economic reports. All of that would have been part of the wrongful death action, correct?
Correct.
But somehow, because he was subject to workers' compensation, now that's not part of the workers' compensation recovery? I don't understand that.
The workers' comp action is a separate administrative action that was filed with an administrative law judge. In this, and it's a statutory framework, and since my client was a surviving heir and there were no minor children, she was entitled to all of the death benefits, which are capped at $300,000. They're paid weekly like wages. And so the Old Republic and myself entered into an agreed award that an administrative law judge signed, awarding her $590 a week, that being the cap at the time, till she receives $300,000. So theoretically, under the statute, they have a valid lien up to $300,000, but it only attaches to a third-party recovery for damage, if the damages are not found to be non-duplicative and for loss of consortium and loss of services to a spouse. So it's the interpretation of that statute, and in this particular case,
Just mechanically
Yes.
speaking, where are the funds? I mean, how does
sitting
that?
in escrow in my account.
Okay.
They have been since 2014.
So, it is the state work. I mean, assume with me for a minute that you should be able to present this claim to some court somewhere.
Yes.
Why is the wrongful death state court the right place to do it when it's really a workers' comp lien
Well,
dispute?
the administrative law judge wouldn't hear it. He thought that a court meant a federal court. There's no case out there that tells us, based on this current statute, who makes that determination.
I mean, typically, if you have a lien dispute, you're going to resolve that in a court that's hearing the lien dispute. And you
well-
went to a court that wasn't hearing a lien dispute. You'd filed a wrongful death action.
And I'm not sure exactly what you're asking. Arguably, I think I could have filed it in any district court in the state of Kansas, as so long as I brought them in as a party, they being the lien holder. And we had both parties in the action.
And what are you filing?
Yeah, that would.
Yeah, what are you
I'm
filing? I think that
I'm filing a motion to determine the validity, not the validity,
in
the
a
amount of
wrongful
the lien.
death action, right? You're
Well,
filing
no,
a motion in a
it's-
wrongful death action.
It's in a workers' comp claim.
You can't just go into a court and file a motion. I mean, you
Oh,
gotta
I
have
agree.
a
And
case.
I had a pending wrongful death action in state court.
Why isn't this a deck action? Separate
Exactly.
deck action?
That's-
If you want
that's
to be in
essentially
court as
what I'm
opposed to
asking.
as opposed to before the administrative law judge, why isn't this just an independent deck action?
It could be.
Yeah.
I'm saying-
because that's the trouble. It is it may not be a violation of the one action rule, but it's a splitting, really, of the cause of action, isn't it? You litigated it in federal court, you got a settlement, and now you want state court to
We
do a
settled
piece
it
of
in
it.
federal court. We didn't really litigate it in any court.
Well, you got a settlement though.
Yes.
The action ended,
Yes.
so that's a difficulty too.
Yes. But
I know I
but-
stopped you earlier when you started talking about the second order, but now I want to talk about the second order. Okay. Just overlook the procedural problem for a moment. In the middle of page 3 of that order, the one dated, signed the 10th of February 2016, there's a reference by the court that your client, quote, represented that she will satisfy the workers' compensation lien pursuant to either a negotiated agreement with the lien holder or in accord with an order issued by state court. He cites a document there. Judge Murguia cites a document in the federal record. Is that document somewhere in our record? Because that's worded differently from your journal entry on the settlement in federal court. Do you have any idea?
Well, that was probably our motion asking him to reopen the federal court case because the district court case said that it could not address the lien issue because the federal court case had already decided the
Yeah, I
lien
know
issue.
exactly what he did. Assuming you're right that that's what he's citing there, that motion itself is not in our record, is it?
It is not.
Okay, thank you.
It is not.
Alrighty.
Any more questions? Thank you, counsel.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Kyle Sollers, and I represent the interveners and the appellees in this matter. And
Counselor, before you get started, can you tell me how your client ordinarily enforces its liens?
well, as to my specific client, I'm not sure I can validly tell you how they normally do things.
You know
there.
where I'm headed. Ordinarily, you have a lien holder that's entitled to money that was recovered by a victim of a tortfeasor, and you make demand. If you don't get it, then you file an action to enforce your lien.
Sure.
And would that be in state court?
I mean, it could, and
So
especially,
is the problem here is that this was filed as part of the of the wrongful death action?
I think
Because wouldn't you agree that the district court would have jurisdiction to resolve a dispute between the lien holder and Ms. Heimerman?
I think that to say that there was only one problem with this case is oversimplifying it. In my review,
Well, my question is, would Allen County District Court have had jurisdiction if you had filed an action there, claim to enforce the lien of National or Northern Clearing?
assuming those facts that we had filed this action first, and it was the case that went to judgment, sure, because then it would have had jurisdiction to award damages, apportion damages,
Well,
etc.
why wouldn't that still be the case regardless of what happens here?
Because the federal court has already awarded those damages. It was the first court to take on jurisdiction of the matter of the parties. The federal court action was filed in September 2013. The Allen County action was filed the following month.
You're saying an
Awarded-
apport.
Yeah, go ahead, excuse me.
I just, are you disagreeing with your opposing counsel? You're arguing that the apportionment has actually been made.
I would argue that based on the face of the federal judgment, all matters as it relates to the damages awarded in the wrongful death action have been accounted for. And in fact, what I was going to start with was some factual statements he made that I think are simply not true. He started off by saying that the lien issue was reserved. That's simply not true. I'm looking at page 169 of volume 1 of the record, and paragraph 24 of that journal entry specifically requires Pamela Heimerman to satisfy any and all valid liens, including the workers' compensation lien. So it was contemplated. To somehow say that that issue was carved out is simply not true.
He's arguing validity. I mean,
Sure.
that's where you're right. That doesn't say they're reserving it. You're right. That language isn't there.
Right.
But it does say valid. And the question here is whether your lien, the entire amount of the judgment, or the amount of the settlement that she received, her portion of the settlement in federal court, whether it is all subject to the lien. That's the question here. That's
Sure.
what everybody's fighting about.
And I think that
So why can't this whole thing just go away and you go do what you would ordinarily do? Contest the scope of your lien or the amount of your lien in a different action, a deck action filed by one or the other of you in state court.
I think that's the only valid mechanism that Pamela Heimerman would have to do that.
So you don't argue that that would be inappropriate even at this point?
Well, I'm not admitting that it would be appropriate, but
Okay.
I'm saying based on that suggestion, I don't see how else she can get past the procedural obstacles that she has in this action. This was a wrongful death action brought as a class representative on behalf of all heirs at law of Mr. Heimerman.
And it
That
was
includes
wrongful
her.
death in state court as well.
It was, yes.
They were two basically companion actions, and one of them was stayed or put on indefinite hold pending the resolution of the other one.
What I think happened is Pamela Heimerman was straddling both cases at the same time, seeing which one would get to judgment first.
She was not an original plaintiff in the federal court.
She was not. Lucas Heimerman, a Florida citizen, brought it against a Kansas corporation. That's why there was complete diversity.
Right.
And she intervened in that action. What I think she did is she straddled both cases to see which one would get to judgment first and then participated in it. Now, she can't come to this court and say she did not participate in the federal court action. There's a pretrial order that's part of the record in volume 1. I have it marked as pages 66 and on 176. And there are allegations that she puts in the pretrial order in the federal court action that lists the itemizations of damages that she was looking for. Part of that is marital damages. She can't come to this court and say that it was just never brought up. That pretrial order superseded the pleadings in that action. She put it at issue. As to why those damages weren't apportioned the way she wants the Allen County Court to do it, I simply don't know. The only
But
reason...
that doesn't tell us that none of the money was attributable to that. It just tells us that those damages are, if they exist, are included in there somewhere.
Yes, and I think that the...
Well, that hurts you though, doesn't it?
No, I don't think so. I think the broader question is resolved by two cases. One would be this Houston versus Highway Patrol, which says that if you have a bulk settlement that's not apportioned, then the settlement award attaches to the entire thing, which that makes sense. If you look at the workers' compensation statute, the way it works is the only thing carved out is an award for loss of consortium and loss of services. because those are not duplicative of workers' comp. You don't get those things in workers' comp. And I'll address one more thing he said about the 1993 amendments to that statute. He makes much about these amendments as being somehow a sea change in how this court views that statute. Other cases, there's a Wishon case, Wishon, that cites the McGranahan case. McGranahan, I think, was in 1990. It predates the 1993 amendments. It held, before the statute specifically said loss of consortium is not subject to the lien, it held that the lien holder doesn't attach to loss of consortium damages because they're not duplicative. So what Wishon and other cases this court has decided has said is the 1993 amendments did nothing more but codify McGranahan. It wasn't some sea change. It was taking what this court had said and codifying it in the Kansas statutes annotated. So this argument that somehow Houston, which was decided before the 1993 amendments, is somehow changed by that, I think is incorrect.
Let me just ask one more question, and
Sure.
then I'm just going to let you make your argument.
Okay.
There's no reason you can't make all these arguments in the deck action we refer to, is there?
No, and I think that,
All right, that's all.
Sure.
I will now stop bothering you and let
Sure.
you.
So
No.
are you in essence asserting just a general issue preclusion argument that applies in any action where you've put matters in issue, then you have to resolve them in that action? Is that the base of what you're arguing?
I think that's part of it, Your Honor. I think general claim preclusion law, and this is more than just issue preclusion. This was a settlement by agreement. We're talking about full-on claim preclusion. In fact, paragraph 25 of the federal journal entry says that the defendants are forever discharged from any and all civil liabilities from the injuries and wrongful death of Dan Heimerman. So what Pamela Heimerman's asking this court to do is actually kind of strange. She's not only asking for the whole matter to be reopened, even though the federal court judgment says it's closed and discharged, everyone go your separate ways, but she wants a state court to review a federal court's judgment. And in my supplemental brief, I reference some federal case law, this Robertson versus Bartels case.
Counsel, can I just interrupt you there and ask very specifically, where in the federal court did it enter a judgment that would have set the scope of the 54OB lien?
I think that the way that question is phrased is to somehow presuppose they were required to. Mr. Mann, when he came up here and argued...
Well, you're saying that we can conclude that by the absence of something, by the absence of a ruling, that settles the matter. That's what I'm at. I mean,
Sure.
Do you agree?
And that's in line with this court's Houston case, Houston versus the Highway Patrol.
So there really hasn't been an apportionment. And the question then is, does that mean that there can never be an apportionment?
My answer to that is twofold. There has been an apportionment in at least some manner. Note that
That's what I'm at specifically. I mean,
there's been an apportionment, for example...
between the heirs, right?
Yeah, exactly.
But the federal court never purported, it never said, I'm going to apportion 100% of this settlement to be not consortium damages. And that was 0% consortium. It never said that.
No, and that's correct. They never did. But I think under this court's Houston case and under the Court of Appeals case in Varner, when a judgment does that, the lien attaches to the entire recovery. And that makes sense with the face of the statute. The way the statute operates is if you have a damages award, the lien attaches to the whole thing. And if you want to carve out from that, you have to say that part of it is for non-compensable losses, loss of consortium, loss of services. So this case is...
You're saying that the statute would dictate your position that there are no loss of consortium damages here, but then earlier you said, well, this isn't statute driven because by case law it's non-duplicative and you couldn't have got to it anyway. So I guess I'm a little confused. Is you're basing your claim to 100% subrogation on the statute or on case law saying it's non-duplicative, or on both, or?
I think it's on both, Your Honor, and I think that both authorities...
And if it is on both, then obviously before there wasn't any statutory construction going on or interpretation, there was litigation on what's duplicative and what's not, right? And so was that, wouldn't that be a matter for a lien enforcement declaratory judgment action, or in other words, why can't that be part of the in-state court?
Well, unraveling that, I think there are lots of different issues that when there's a bulk settlement that doesn't say that it's for one item of damages that is not compensable in workers' compensation. I would cite the Jerby case, for example, that both parties cite in their briefs. This is from the Court of Appeals. That when the judgment releases the defendants from all liability, it's duplicative as a matter of law of the lien. The lien attaches to everything because it's duplicative. If for some reason this settlement only released part of the claim or part of the parties, we'd have a different discussion. But under that Jerby decision, it's duplicative as a matter of law. And putting that with the Varner case and the, I'm sorry, it's escaping me now, this court's case, what it means is that if it's for the entire, if you release the defendants from all liability and it's a bulk sum settlement, it's not only duplicative, but it attaches to every dime of the settlement.
I'm sorry, I'm not understanding what the significance of releasing defendants, because we're not talking about defendant liability, we're talking about how much lien your client has on that recovery. No one's asking the defendants for more money. They're just asking that the insurance carrier not take all of their money.
Sure.
And so why are the defendants any part of this? And why does what they released liability for have anything to do with the price of wheat in Kansas?
The analysis in this Jerby case that I'm citing talks about the effect of a workers' compensation lien and the idea of duplicative damages. What the Court of Appeals held in that decision was that if the settlement released the defendants from all liability, then the lien amounts that are sought are duplicative as a matter of law, meaning dime for dime, it attaches to the entire thing. You match that case with this court's decision in Varner, then what you have is if it's a bulk settlement that releases the defendants from all liability, it's a duplicative settlement. It attaches to everything because nothing was removed. Nothing ever removed itself into non-compensable losses. And I think that that is really the central problem that Ms. Heimerman's running into, even above and beyond the procedural hurdles that she cannot overcome.
It sounds like you're really boiling it down. You're just saying the Court of Appeals in this case got it right, and that it's the court that approves the settlement that has to do the apportionment under 504B.
I would say,
because once that court is done, it's done. That's your argument.
It has to be a court with competent jurisdiction. Let's put it that way. And you don't have that here. Upon what statutory authority does the Allen County District Court have to modify federal judgment? There is no statutory authority for that. Federal law dictates the avenues and procedures for reviewing a federal judgment. For example, go ahead, Your Honor.
I may not have been paying close enough attention, or maybe this has not come up. Is it your position that another action cannot then be filed for the loss of consortium issue in federal court? Can you go back, can the claimant here go file another action in front of Judge Murguia and say, we now want to litigate the validity of the workers' compensation lien pursuant to paragraph 24 of the journal entry you signed?
No, Your Honor.
And why is that?
Because the federal judgment was a wrongful death action brought on behalf of all the heirs of law, including her, and any items of damages that any of those heirs of law might have had. And again, I cited that pretrial order where she puts the very damages that she's trying to put at issue here. She's talking about her marital damages. They were brought up in the federal court action. She had her day in court. Her counsel came today and said that she did not have her day in court, but she did. A wrongful death action is one action. the one action rule that this court brought up earlier. It is brought on behalf of all the heirs at law, and you get one action at it. The defendants cannot be brought into court to answer twice, which is precisely what she would have to do to do what she's asking the Kansas courts to do.
Okay.
So even if paragraph 24 is correct, it's your position that it has no force and effect. It just could not have been there to have any validity. Judge Murguia's journal entry, paragraph 24.
Sure. I think that's a valid order. I mean,
Well, what purpose is served by paragraph 24? Basically, as your opposing counsel's arguing, that was saying we're going to go pay or satisfy all valid liens, and by that we're still going to litigate the validity, i.e. the amount of the liens by the workers' compensation insurance carrier. And it sounds like you're saying that was a waste of text because it had to have been litigated in front of Judge Murguia. Is that right?
Well, it was a settlement by agreement, so to say that the issue was actually litigated, I'm not necessarily sure that's true. But in interpreting paragraph 24 of that journal entry, I don't think it's saying that we're going to go determine whether this lien is valid. It's assuming that it's valid. Go satisfy any and all valid liens, including the workers' compensation lien. So the federal court determined that that lien is valid. There's no further litigation that's needed. And in fact, this court's decision in Smith versus Russell, which is cited in the Ballard case that both parties cited, says that there's no litigation required in order for a workers' compensation lien to arise. It arises automatically as a matter of law. So really what Ms. Heimerman is proposing is this kind of strange situation where we're going to go litigate something that doesn't actually have to be litigated.
I'm sorry. I don't think anybody's disputing that there is a valid lien of some amount. What opposing counsel's arguing is that this gave them the right to go argue about the amount of that valid lien.
I don't read it that way, Your Honor. If there is a dispute as to that, she would first have to get past the procedural hurdles, which I don't think she can. This was a federal judgment. Upon what statutory authority does any court in this state have to review or even modify that judgment? And
well, my question was, can they go back to in front of Judge Murguia and say, we now want to litigate what was expressly reserved according to opposing counsel, and that is the amount of the lien. And that underlying issue is how much is attributable to loss of consortium or loss of services.
I think the beginning of your question is actually the answer of it. If this issue is live, like Ms. Heimerman claims it is, she can file a Rule 60 post-judgment motion with the federal court asking it to determine the issue and tell the federal court, listen, we messed something up, there was excusable neglect or whatever the case might be, we want you to reopen the case.
Were you a party to that wrongful death in the federal court?
No, Your Honor.
Well, then what they're saying right now is we got a dispute, Ms. Heimerman and Northern Clearing Insurance Company, we have a dispute. And why do they have to go back to an action in which you're not even a party in order to get a judicial determination of what your lien is against her?
I think that conflates two issues, the issue of what the damages are and the validity of the lien. They are intimately tied.
Well, the question was, could they go back to federal court? And what I don't understand is, why couldn't they go back to federal court? Pamela Heimerman versus Northern Clearing Insurance Company, a declaratory action. We want you to determine if any of these damages are duplicative for purposes of Kansas workers' compensation subrogation.
I suppose there's nothing stopping Ms. Heimerman from filing a declaratory judgment action. I'm not necessarily admitting that that is proper or even would succeed. We might still run into the same res judicata problems. But what I can say is that based on the procedural posture of this case, she simply cannot obtain the relief she's requesting in the state of Kansas. This was a federal judgment. There's no statutory authority for a Kansas court to review, modify, or vacate what a federal court has done.
So we're back to basic issue preclusion, that she put in issue these are my specific types of damages in the federal action, and if there was any place she was gonna litigate it, it had to be litigated in that action in which she put that in issue before it reached final judgment.
In this case, yes, Your Honor. That court dealt with all the issues. It seems rather strange to turn to another court system, not just another court in the same jurisdiction, an entirely different court system, and ask them to change the judgment.
And she could have litigated the validity and extent of your lien even though you were not in that action.
I believe she could have, and that is, reading this court's case law, for example, Smith versus Russell, that's exactly what happened. They apportioned the damages to loss of consortium, and if I'm not mistaken, it was 100% loss of consortium. And the lien holder was totally wiped out in Smith versus Russell.
Would she really be litigating the validity of your lien, or would she really just be litigating her damages?
It'd be her
And
damages.
then that would have the collateral effect of determining the validity of your lien.
Yes.
But it wouldn't be, the issue wouldn't be phrased in federal court as, is this lien valid? Is that, am I correct
I think
in
that's
that?
a correct analysis of how the lien statute operates, in my opinion.
You would then go file a separate action to say, we now have a lien on these proceeds and we have to accept Judge Murguia's finding, judgment that, let's say, $50,000 was of that settlement was for loss of consortium. Is that right?
If this matter were to continue at all, which I obviously hope it does not, it would have to proceed in a court with competent jurisdiction. So the court mentioned a declaratory judgment action.
No, how would you enforce your lien is my question.
If the proceeds were not paid to us, we have different avenues. For example, it was mentioned earlier, the Workers' Compensation Division, the administrative aspect of this. The law allows employers that have paid these workers' comp benefits a credit on future payments of workers' comp benefits. As we speak right now, she's receiving these weekly benefits. Well, if we have a lien such as this, the division can stop those future payments as a credit, saying, look, we see this subrogation lien, you guys have a credit for that. On top of that, if we don't get paid anything from the settlement proceeds that are being held in escrow, we can file a motion to enforce on it. There are different avenues we can do it.
And where do you file that? Administratively?
I think would be with the federal court. I mean, the federal court clearly took up the issue in paragraph 24 of its journal entry.
So you would file a motion to enforce in the action in the federal court in which you were not a party?
Either that or a separate action to enforce. There are many different avenues that we could take to do this. What I'm saying is that what's being done in this case is not one of them. There's simply no statutory authority for what Ms. Heimerman is asking the Kansas courts to do.
If the settlement agreement in federal court had not only apportioned between the son and the widow, but also as to the widow said everything she's getting is exempt from your lien, wouldn't you have intervened to say, slow down, Judge Murguia? That's not right. That can't be right.
Sure.
And so then it would have been decided in the federal court, which had jurisdiction over the proceeds.
Sure.
And I guess what I'm seeing is plaintiff's motive in not bringing that issue up is because these other guys want to pay their money and be done. They don't want this litigation to go on. And so this conundrum has been created.
Sure.
But that's what you would have done. You would have been there, Johnny, on the spot saying, wait a minute, all this money is not exempt.
Right.
And that's where it should have been litigated.
I agree, Your Honor. And to that point, had we not intervened, which we did not in the federal court action, and it had gone the other way, and there were some amount of damages that were attributable to loss consortium, we likely would have been bound by that judgment. And I think that is indicative of the preclusive effect of that judgment. We may not have been specifically a party to it, but we would have been bound by it anyway. So I think now that the roles are reversed, it seems a bit disingenuous for her to say that that judgment doesn't bind her. She can go back into court. She can relitigate her damages completely with the obvious hope of defeating a lien on her recovery.
You would have been bound even though you weren't a party.
Well, I mean, there's a line of case law that deals with insurance companies that fail to intervene in a case,
Okay.
and they end up being bound by that judgment. So this really goes to the preclusive effect of what was done here. I think that we stand in privity with the parties that did litigate this issue, and for her to step back into court and relitigate this issue, she's really trying to get a redo. Her counsel stood up here earlier and literally said that she's asking for a recalculation of damages. How is that not relitigating a claim that's already been decided? Not only already been decided, but decided by a different court system. It would not only offend, there's no subject matter jurisdiction because there's no statutory authority to do that, but it also offend res judicata and the rule of comity. We want litigation to eventually come to an end. And if these parties have already brought this issue down to a judgment, we're not going to blow the whole thing up just because a party wants a redo. And that's exactly what this is.
Justice Stegall, you had a question about 15 minutes ago.
I'm
and
good,
You kept
thank you,
getting
Chief.
interrupted.
If I didn't answer it, I can
That's
try
fine.
again.
No, he didn't get a chance to ask his question.
I'm fine.
All right, very good. Any more questions? All right, thank you, counsel.
Thank you, Your Honors.
We thank both of you for your arguments this morning. Court will take this matter under advisement.